Have you ever paused to consider the fundamental foundation of your employment agreement? It might seem straightforward, but employment laws vary significantly across the United States, especially when it comes to the widely accepted concept of at-will employment. Most states in the United States operate under an at-will employment doctrine, meaning an employer or employee can generally terminate the relationship at any time, for almost any reason, and without notice. However, a few states have enacted unique provisions that significantly modify or even reverse this traditional rule, offering additional protections to employees. The core mechanism of at-will employment stems from the idea that, just as an employee is free to leave a job at any time, an employer is also free to dismiss an employee at any time. This principle is typically limited by three main exceptions: public policy, implied contract, and good faith and fair dealing. Public policy exceptions protect employees who are fired for reasons that violate a fundamental public policy, such as refusing to commit an illegal act. Implied contracts can arise from employee handbooks or oral assurances, suggesting a promise of continued employment. The good faith and fair dealing exception, which is less common, implies that both parties in an employment relationship will act fairly and reasonably towards each other. To understand the specific rules applicable to your situation, it is crucial to investigate the employment laws of your particular state. Begin by reviewing any employee handbooks or written policies provided by your employer, as these documents can sometimes create implied contracts. Additionally, familiarizing yourself with your state's Department of Labor website can provide general guidance. However, for precise, legally binding information, consulting with a qualified local employment law attorney is always the most advisable step. Interestingly, the state of Montana stands out as the sole state that does not adhere to the at-will employment doctrine. In Montana, an employer must have good cause to terminate an employee who has completed an introductory probationary period. Beyond Montana, other states have varying interpretations and applications of the three exceptions, with some states more readily recognizing implied contracts or expanding public policy protections. For example, some states explicitly protect whistleblowers or employees who report illegal activities from retaliation. By understanding these state-specific nuances, you can better appreciate the legal landscape governing your employment. Recognizing whether your state has adopted significant modifications to the at-will doctrine empowers you to navigate your career with a clearer sense of your rights and responsibilities, promoting a more informed and secure work environment for everyone.